Anthony Parr, Rebecca Taylor, William R. McHugh III versus David Cougle, et al. And Judge Oldham is here with us. Judge Oldham, can you hear us? We can't hear you. I just wanted to make
Sorry, I can hear you great.
Okay, thank you. And if he may have questions as well, but just wanted to make sure he is fully participating and wanted you to know that. And Judge Wilson is also here. So let's hear from Mr. Bolner, please.
Good afternoon, Your Honors. James Bolner here for the District Attorney for St. Tammany Parish. The question presented in this appeal is whether or not the evidentiary privilege extended to members of a legislative body applies only in instances where that legislative body is enacting a binding law. Specifically in this case, the issue is whether or not a non-binding resolution is the type of legislative act that falls within the purview of the legislative privilege.
Counsel, let me interrupt you real quick, just because there is another issue lurking, and I'd like to get you to comment on it if you could. What do you do with Jones versus Reeves?
I'm not familiar with that case, Your Honor.
It's a recent case that involves an institutional injury. The Jackson Municipal Airport Authority Board over in Mississippi, my neck of the woods, and basically the court held that the plaintiffs there had no standing. They were individual board members because what they were basically alleging was an institutional injury. Therefore, the board itself had to bring the action.
I am familiar with that case. I identified it as the Harkins case, and this related case be the Stallworth case.
It was called when one of the iterations, that's what it was
called. And I think
yeah.
Your Honor wrote the opinion and went to an en banc, and it was dismissed as moot. That is an issue that we have thought about, but
This is a subsequent iteration of it that came out in November 19th, I believe.
About 2 weeks ago.
So
I'm sorry, Your Honor. I don't know what happened in connection with that case. I am familiar with the other two cases.
I think that if you have any thoughts on the standing, we'd be happy to hear them. And I would ask that perhaps y'all could prepare simultaneous letter briefs on the standing within 7 days, if that would be satisfactory. Each side.
Yes, Your Honor.
Because I think that is a lurking, obviously, and standing is a preliminary issue.
Well, Judge, I honestly can say that I would welcome a dismissal of the underlying lawsuit. However, that still leaves Judge Long's ruling on legislative privilege out there. And I think the ruling is such that it impacts more than just St. Tammany Parish. It impacts every parish council, every police jury in Louisiana who acts as St. Tammany Parish does through the legislative vehicle of a resolution. And I would hate to see this reported case on the books. But having said that, the three individuals are not board members anymore. They were no longer board members as of June 1st. They asked for a TRO before the effective date of the resolution, and Judge Long did not grant it. So I think that's my answer to the question of standing. I don't think they have standing to assert First Amendment claims.
Thank you. Well, and obviously, without prejudice to you briefing the issue once you're familiar with the new case.
Thank you.
And so, turning to whether the resolution is legislative and within the privileges scope, would you like to address that issue?
Yes, Your Honor. I think that the test for that, which I would start with, is the Tenney case. And that, of course, is a Supreme Court case where the Supreme Court said that the court should not go beyond the narrow confines of determining that a committee's inquiry may fairly be deemed within its province to find that a committee's investigation has exceeded the bounds of the legislative power. It must be obvious that there was a usurpation of the functions exclusively vested in the judiciary or the executive. So essentially what the Supreme Court said, as I interpret it in that instance, was that unless they are going out of their lane, unless the legislative body is engaging in an administrative function, an executive function, then they're a legislative body and they're legislating. Whether you put put it under the heading of an ordinance, a binding law, or a resolution, it's still legislating. This court has on numerous occasions, and the one that comes to mind most obviously is the Jefferson Parish case involving the health carrier, recognized that a resolution may be a legislative act, although that was not exactly the precise issue that was in front of the court in that case. But that did involve a resolution enacted under a charter that identified resolutions in identically the same way as St. Tammany Parish does, which I would add is no different than almost every other parish in the state of Louisiana. We didn't make up our definition of resolutions and make it different than anyone else. A resolution is a non-binding expression of will of a legislative body. That doesn't mean that it's not legislation or that it's not.
But regardless, we're not dictated by what the parishes in Louisiana define as a resolution or an ordinance, are we? We look at the character of the act that's at question.
Exactly, and in this case, there are two components to that. Did they follow the normal procedure for enacting a resolution? Absolutely. There were two different drafts of this particular instrument. It laid over. It was voted on in a public meeting. It was adopted in a public meeting. It had all the hallmarks of a resolution. But more importantly, this resolution effected a significant policy change. And that policy change is it gave the newly elected council members of St. Tammany Parish Council the ability to reconstitute the board and going forward to appoint 2 new board members every year by staggering the terms. That staggering was done to make the board consistent with Louisiana law, 25-214, which I would just, as an aside, point out that 25-214 staggers the appointments of library board members. It does not pertain to any other board, but that doesn't mean that the council wasn't also simultaneously, as is reflected in the record at I believe it's ROA 335, also simultaneously engaging in a process of reconstituting and staggering appointments to all other boards in the parish, planning and zoning, fire protection boards, etc., that were not staggered but were required to be staggered by Louisiana law or by parish ordinance.
Is the question of whether the board had the ability to truncate these 5-year terms relevant, or is that an issue?
It has not been. I don't think it's an issue for legislative privilege. It might be an issue for the underlying claim. But legislative privilege should not have any bearing on whether or not there's merits to the underlying claim.
Well, I guess I'm asking maybe because I'm trying to figure out, is there an ultra-virus issue that's lurking here? Because if the council acted ultra-virus, they did something they had no power to do, would that not vitiate the privilege or at least set it to the side?
I think if you were talking about immunity, if you're talking about legislative immunity, yes. But if you're talking about legislative privilege, I don't think that vitiating legislative privileges is applicable because you say it was ultra-virus or there was some motivation behind the enactment of the resolution. You don't lose the privilege, as they said, as the Supreme Court said in Bogan. It's not about what the intent was.
No, but I'm asking more about the legality. So, simple question. Does a subsequent parish council have the ability to basically fire these board members even though they were appointed to 5-year terms?
I believe that they do, absolutely. There's a provision in state law that says that the parish council can fire any board that it appoints, and that's the library board included. And that legislation was specifically amended in the last session. But as a home rule charter parish, I believe that we have the authority to do that as well. I don't know that we even needed state legislative authority to do that. I think we already had it. So the home rule charter allows us to create the library, and essentially we operate, so long as our general laws are not in conflict with the state laws, our ordinance is not in conflict with the state law, then yes, the parish has the authority to do that. And again, I think that does go to the underlying claim.
Where is the what is the situation with the documents at this point? They were, originally to be produced in August. So is
That was stayed.
stayed?
Yes.
And is there something that's going to be happening imminently that we need to be concerned about? I think we're doing fairly quick proceedings and.
There is not. There is not. There was a hearing on October 15th and 16th on the plaintiff's motion for a preliminary injunction. That's done. And at that hearing, the judge treated his ruling as if he had ruled in our favor and stayed the effect of the ruling in favor of the appellees. So, yeah, there's nothing that's out there in that regard.
Okay.
So to go to the question of waiver and the question of
Back to the standing, you expressed some concern, and obviously this wasn't something you prepared to discuss, that you were concerned that, well, you'd really like the legislative privilege to be addressed.
yes,
But if there wasn't standing to begin with, then that wouldn't stand. That would be vacated, wouldn't it?
I would hope so. I could live with that.
No, I'm not trying
Right.
to foreshadow or assuming. I'm assuming arguendo. I assume if there was not standing, then the ruling would not be on the books, as you said.
I would agree, and I also, the other issue is jurisdiction from the standpoint of have these folks articulated an actual First Amendment retaliation claim when the basis for their claim is that they want the ability to get back on the board to speak for the board. Their free speech claim is the right to engage in government speech, and that's another issue that I think could do away with the case in its entirety. But
That goes to the merits of the claim, does it not?
absolutely.
So one more standing type issue. I would call them the defendants, but basically there are these other parish council members who joined the motion in limine, I think it was, in the district court, but they never intervened in the case, and now they're here on appeal. Is there a problem with that?
I don't think so under Hughes and Banc Courtroom and the Lulac case. I think that's kind of the way it's been done. However, as distinguishing this case from those cases, in this case, 3 of the appealing council members did get deposed, subject to, at least in my mind, a stipulation that we were reserving our right to preserve the legislative privilege and blanket objection to any responses. And we submitted those deposition transcripts, 2 of them. One of them wasn't prepared at the time we were on the eve of the first trial date. We submitted those for in-camera review to the trial court. We identified the portions of the deposition transcripts that we felt went to the legislative privilege issues. So those 3, there's a 4th council member, Councilwoman Casabon, who there was talk of subpoenaing her to testify at trial. We filed a motion to quash her subpoena. The other 5 intervened as participants in the motion in limine.
Well, they just joined the motion. They didn't
They did.
intervene. They didn't come on as interveners.
I don't think that in either Hughes or Betancourt that the state legislatures
Well, no, I guess
formally intervened either.
the question is, did they adequately participate in the litigation below? And I guess your position is they did.
Yes, it is.
It is an odd posture, though.
It is, Judge, and the roadmap, if you will, for how our office dealt with most of this case was the Hughes and Betancourt and Scott decisions, where we felt like we did have to produce a privilege log, as was required in the Jackson case. We did have to allow these depositions to go forward, and we did have to engage in discovery, and that's the way we addressed those issues.
Judge Oldham, do you have any questions? No. Okay. Thank you.
Thank you, Judge.
Thank you very much. Mr. Hamilton.
Good afternoon, Your Honors, and may it please the Court. I am Bruce Hamilton on behalf of the appellees, Anthony Parr, Rebecca Taylor, and William McHugh. I want to start by picking up on a question you asked, Judge Wilson, and I think it is a threshold question, one that has been given somewhat short shrift by defendants' briefing and argument today, which is a question of standing, but not the first question issue of standing you posed. There are only two party defendants in this case. That has been the case all along. Two official capacity party defendants, the St. Tammany Parish government and David Cougle in his official capacity. Something very curious happened when the Parish Council when defendants filed the motion in limine on August 5th. For the first time, 8 members of the Parish Council, quote unquote, joined in the motion. But as you pointed out, Judge Wilson, they never intervened. They never filed a motion to intervene. The judge never granted a motion to intervene.
Which is odd, but then you run up against Betancourt, where those legislators were not parties either and had not even participated in the case that was before us. They participated in a consolidated case. We said that was good enough.
Well, Your Honor, this case is distinguishable in the sense that those legislators were brought into the litigation through third-party subpoenas. That is
so weren't these?
No.
Weren't they?
No, Your Honor. Respectfully, 5 of the Parish Council members, Seiden, Burke, Rowling, Laughlin, and Smith, have never been deposed, have never been the subject of subpoena, and no documentary request or other discovery has been directed at them.
Well, but that doesn't mean, they possess their own legislative privilege. It's personally held. So to protect it from other discovery going on in this case, they had to do something, right?
Well, not necessarily. Because it's personal to the legislator, they may raise it in response to specific requests, but asserting it broadly with respect to requests of the government, I think, is a little bit far afield from how the privilege generally operates. But
if they didn't raise it, then their communications might be encompassed by someone else's.
Perhaps, Your Honor, perhaps. But my point is that they never invoked it themselves in response to any discovery.
But by joining the motion in limine, they invoked it.
Perhaps, Your Honor.
The only other way they could have had it invoked, Cougle couldn't invoke it for them, right?
That's right.
And the third-party witness might have invoked it. That was Hughes, if I remember right. But if not, then the legislator has to invoke it themselves. That's Betancourt.
Right, but Rule 26 is very clear that in order to, the party invoking the privilege has the burden of showing their entitlement to the privilege, and they have to invoke it in response to a specific request or inquiry. I think what you're describing is that...
But it doesn't have to be a specific response or inquiry to that person. Couldn't it implicate their legislative privilege by a third-party request to a different witness?
Perhaps.
But again, that's Hughes.
Well, Hughes and Betancourt did extend, and for the purposes of this appeal, we are not challenging this court's holding that the legislative privilege may protect communications between legislators and third parties. But this is somewhat a different question. It's whether a legislator who is not a party may assert it with respect to discovery that's propounded to other defendants or to the government.
What difference does this make in this lawsuit at this time?
Well,
if there is, in fact, if we have to decide whether we have standing and whether the district court had standing. We have to decide whether or not there is a privilege at all. And if we were to decide assuming argument that we would decide that there isn't legislative privilege that applies, does it matter whether these people are actually interveners in it or not at this point?
Well, it
Proper
does to the extent that
interveners. How does that matter?
How does it matter?
Yes, why does that matter, whether these particular, if we're resolving the issue and if the issue were resolved negatively, wouldn't that be the end of it?
I'm not sure I properly understand your question, Your Honor. Judge Elrod, if you're asking whether it matters whether they're interveners,
Yes,
I think it does. And
Why?
Because it is because legislative privilege is a fact-specific inquiry, and the application of the privilege depends on how it's invoked and in response to what? In response to a discovery request, in response to
are you
testimony?
saying it's been waived or something by these people?
No, I'm saying they have, the evidence at issue in this appeal is a couple recordings, 4 deposition transcripts, and some other discovery requests, some other documents. The recordings at issue involve Parish Council member Corbin and Parish Council member Tanner. Neither of them has invoked the privilege with respect to that recording. In fact, that recording, no one has tried to introduce that recording into evidence, and it's not in the record. With respect to the deposition transcripts, none of those deposition transcripts is in the record. One of the depositions was taken after this appeal was lodged. The other 3 were apparently submitted for in-camera review, but they are not part of the record. So there's no way for this court to assess the judge's particular factual application of the privilege to the statements in that deposition. And frankly, Seiden, Burke, Rowling, Laughlin, and Smith don't have standing to assert legislative privilege with respect to the depositions of other council members.
Well, but I think that runs headlong into Hughes and Betancourt. If anything, if Betancourt, if the appellants there had standing to bring the appeal, they had participated enough in the underlying action, then this case seems much stronger because these parties, we'll call them parties, joined a motion in limine squarely on point, squarely on involving the issue of legislative privilege, and I fail to see why does it matter. In fact, what Hughes and Betancourt were about is that the parties there couldn't go around the legislators to discover the same information they couldn't get from the legislators because the privilege extended to those third-party communications. It seems like all of that is balled up into the same issue here, too.
I don't think so, Your Honor. Third parties are outside the legislative process, and we're talking about...
No, not always. That's squarely against what Hughes says and what Betancourt says.
All right, excuse me, Your Honor. My point was that third parties are not legislators. The 5 other parish council members in this case who apparently joined in the motion waited until August 5th. Throughout the pendency of the case, they were not engaged at all. There were discovery requests that they did not engage with before the motion in limine.
So the argument is they engaged too late.
Yes, they engaged too late, and they did not. The inquiry surrounding legislative privilege must be specific to the requests, right? It must be specific to the testimony at issue or the documents that are sought to be disclosed. They sort of generally engaged in this motion in limine, which addresses specific pieces of evidence that don't involve them, such as the recordings. So how can they invoke legislative privilege with respect to the recordings of Mr. Corbin and Ms. Tanner when they are not those people?
Well, that sounds like a waiver argument.
Well, there is a waiver argument as well, Your Honor.
I mean, Chief Judge Elrod asked about had they waived it and whatnot. I didn't hear that in your answer, but that sounds like a waiver argument.
Yes.
All right, well, be that as it may, let's talk about the plaintiff standing. How did you deal with Jones versus Reeves?
Your Honor, I also am not aware of that case.
Do you have any thoughts on standing?
I do, generally.
Well, specifically, how is this not an institutional claim disguised as individual constitutional claims?
Well, frankly, Your Honor, defendants have mischaracterized the claims at issue in this case. It is not an institutional claim. It belongs specifically to the 3 individual plaintiffs who were volunteer appointees. Their First Amendment claim is one of retaliation, that they lost their positions because of things they said. because of views they expressed.
They lost their positions because the council made a policy decision to restructure the board in accordance with Louisiana law and reappoint based on staggered terms.
That is one interpretation, Your Honor.
Well, but, isn't this an institutional injury to the Board of Control as opposed to any individual that was on the board?
Perhaps, but that is not the injury that the plaintiffs are asserting. They are asserting personal injuries.
Well, they can call them personal injuries, but if it's an institutional injury, they have no standing to bring that, correct?
Standing to bring the institutional claim?
Correct.
Without having reviewed the decision, I would concede that point, Your Honor.
And obviously, without prejudice to you looking at Jones versus Reeves and responding to it, but Jones versus Reeves didn't announce the idea of institutional claims or lack of standing to bring them. It just is sort of our latest pronouncement on it.
Certainly.
Don't see how the former library board has First Amendment rights in this context.
Well, Your Honor, I think perhaps you are taking defendants' characterization of the claims that they are seeking somehow to engage in government speech. That's not the nature of the claim. Their claim is that they were volunteer appointees to the library board.
That has nothing to do with anything. Voluntary appointees are still appointees. They're government officials, aren't they?
They're not speaking as individuals, they're speaking as the library board, aren't they?
I think that's a factual determination that has already been made by the district court. But addressing your question, Your Honor, they were speaking as individuals. They certainly were speaking in their capacity as library board members, but they spoke both as library board members and as individuals. Their speech in this case involves not only what they said while they were sitting as library board officials, but in private Facebook posts, private discussions they had, private statements they made, and public statements they made.
You're saying government officials have personal First Amendment rights in their official actions? I'm just trying to make sure I understand what the argument is.
That is true, Your Honor, but that's not the argument. They have personal First Amendment rights as private citizens.
But they're not acting as private citizens, are they? They're acting as the library board when they're on the library board, and then they're no longer on the library board, and so then they're not acting as the library. Maybe, can you help me a bit?
Sure. I think we're getting a little far afield of the issues in the appeal, but...
Well, I don't think so, because I think it's very pertinent to the standing issue.
Absolutely.
But go ahead.
Judge Elrod, the former members of the library board took actions as library board members. They voted, they spoke on books. That speech is one form of speech. However, they also spoke in their private capacity, in their personal capacity. They made certain statements on Facebook.
So when they were sitting there in the library board meetings, when they were talking about the books, which is the subject, they weren't talking about their plans for dinner or other they're talking about the actual job. They're speaking in their personal capacities then, and that's where they have a right?
They are expressing their personal views of literature. When they're asked to evaluate whether a book or some other library material is appropriate.
But wait a minute. When they're asked to evaluate that, they're acting in their capacity on the Library Board of Control. They're setting policy.
Well, Your Honor, I agree partially. They are acting as library board members when they make those judgments. However, when they speak about these works of art, of literature, and they make aesthetic judgments and they reflect on their own personal feelings about the work, those are personal views.
Okay. I think did you have anything else about the standing that you wanted to say, or you want to reserve that opportunity for the 7 days?
I would preserve it.
Okay.
Preserve it. Thank
And I did not say earlier, but I would ask that those simultaneous letter briefs be limited to no more than 10 pages each.
Yes, Your Honor.
Okay. Do you have
Judge Elrod, can I jump in with a question? Can y'all hear me okay? Can you hear me?
Yes. We can hear you.
Oh, great. I want to just follow up on the standing question because I want to try to put a finer point on it, and maybe, Counsel, you can help me with this. Do y'all have a city administrator in St. Tammany Parish, like a lot of parishes do?
There is a council administrator.
Perfect. So does the council, suppose that the council administrator is at a meeting of the council, and the council says, look, we're going to take this official action as a council. We're going to adopt a policy as to the parks department. We're going to adopt a policy for the public schools. We're going to do something with roads. Here's the official policy of the county. I'm sorry, of the parish, excuse me. You can tell I'm a Texan. Here's our policy as a parish. And then the parish administrator stands up and says, no, I disagree. I vehemently disagree. And then I'm going to go on my Facebook page and I'm going to vehemently disagree there. And I'm going to petition and I'm going to vehemently disagree there. And I'm going to lodge, both individually and in my official capacity as the parish administrator, a bunch of different objections. And then the council removes that parish administrator because it's obviously not a faithful agent of the parish. You're telling me that that parish administrator has a First Amendment retaliation claim against the parish council. I just want to make sure I understand your argument.
Your Honor, briefly, and I hadn't fully considered this hypothetical, but yes, the government employee in that case would have a First Amendment retaliation. I believe defense counsel is incorrect that government speech is not protected. There are various cases, Garcetti and Pickering, dealing with the rights of government employees in First Amendment retaliation.
But that's when they're speaking outside their ordinary duties. That's a key point of Garcetti, and that we always go look to say, was this in the scope? And certainly in the hypothetical that Judge Oldham just asked, the manager person was in the scope. And if you're talking about library books and your job is the library books, then when you're speaking in that context about various merits of certain library books, that's right center in your government duties. So that Garcetti would be bad for you in that case, not helpful.
Right. I agree, Your Honor, but my point is that the plaintiffs are not and have never been government employees. I do think there's a distinction there. Whether or not it's voluntary, they were appointees, but they were not employees.
They're not employees, which I think gets away from your argument, actually, so to me it damns your argument about administrative function versus policymaking function back to the parish council. They're not employees. There's no per diem injury. There's no compensation injury. There's nothing like that. But they are government officials. I mean, I actually served in one of these things. It was a totally volunteer appointed position over the college savings plans boards plans in Mississippi. And I'm kind of with Chief Judge Elrod. I failed to see the line if I'd taken action relating to the 529 plans and the rules governing those, and then go out and speak about it, how I would have a First Amendment claim if the governor or the treasurer, whoever appointed me, came back and said, "You're off, sorry." Isn't that the same thing?
I don't. It may be, Your Honor, but I think the case at hand is not the same thing. The plaintiffs were speaking about their personal views regarding books. This is not, they were not espousing government, they were not making government speech.
What's your best case that shows that dichotomy, where the personal views totally align with the official duties of the position?
I would be happy to submit that as part of the letter brief, Your Honor.
Well, I'm just asking here at argument. I mean, there's no reason that's a new issue.
No, absolutely, and we have briefed the issue of government speech before, but I just don't have a case at my fingertips.
Not so much government speech. I'm going back to official duties versus, in the line of the course of your employment versus something that's completely unrelated. That's not what you're talking about here, and I'm just trying to figure out where is this dichotomy that they can go out and speak on these same exact subjects as private citizens while taking action during the meeting as officials.
Well, one distinction is that when they are discussing the works of literature that are challenged through statements of concern, they're not actually taking an official action. It's only when they vote on the books, whether to ban them or remove them from the shelves or move them to another section, that they're actually taking an official action. I just want to address briefly the fact that defendants are espousing a radical view of legislative privilege that would dramatically expand the privilege in a deleterious fashion. And the most salient example I have of that is with respect to the recordings. Essentially, what they are arguing is that waiver should be restricted such that third parties cannot waive the privilege over communications, their personal communications with legislators. Taken to its logical extent, that operates as effectively a gag order or a prior restraint, because any lobbyist or advocate who meets with a legislator would then be prohibited from disclosing the contents of their own conversations with their boss, their coworker, their friend. It is that runs directly counter to the common law principle of access to government as well as the First Amendment. This court should reject such a radical interpretation of legislative privilege.
Who specifically are the third parties that you're talking about in your case?
Mr. McHugh, one of the plaintiffs, who made the recording. Defendants are asking you
Made the recording with whom?
with
Conversation
with
involved.
Parish Council Member Corbin and Parish Council Member Tanner. They're seeking to prohibit introduction of those recordings into evidence.
Thank you. I believe we have your argument.
Thank you, Your Honors.
Your Honors, in the, I believe it's the United States versus Helstowski. I'm sorry, 442 U.S. 477. The court said waiver cannot be found only after explicit and unequivocal renunciation of the protection. I'm sorry, we hold that waiver can be found only after explicit and unequivocal renunciation of the protection. The ordinary rules for determining the appropriate standard of waiver do not apply in this setting. So what my friend on the other side is saying is that Mr. McHugh, because he recorded these, secretly made these recordings, he can broadcast them out on the airwaves if he wants. That's not how it works. Attorneys don't have the ability or the right to violate their client's privilege. It's their client's privilege. It's Jeff Corbin's privilege. It's Cheryl Tanner's privilege. It's not Mr. McHugh's privilege. And the test is whether or not that information has been released to the general public. And in this case, Mr. McHugh wants to release these recordings, but he does not have that right. When we went to the hearing in October, Mr. McHugh said, well, I can't introduce the recordings themselves. I'll just talk about them from the witness stand. And Judge Long said, absolutely not. That's Jeff Corbin's privilege. It's Cheryl Tanner's privilege, and they have the right to protect that information. Let me address one of the other issues that came up in terms of the participation below. David Cougle was named as in his official capacity. However, discovery was sent out that was to David Cougle in his official capacity in name only. This was information, the information requested from David Cougle was, I want your emails between you and another individual before you even announce that you're a candidate for counsel. I want all your emails relating to the library. I want all your emails relating to various aspects of the library controversy. And we filed motions to quash. We filed a motion for a protective order. We did everything we could to protect David Cougle's, as a council person, his right to maintain his legislative privilege. And he also joined in the motion in limine. I thought we were doing it all right when we followed the roadmap that the cases had set out in beginning with Scott, where they talked about prepare a privilege log, identify what was privileged, and let the court view and make that determination. That determination was not made in this case. There is no question of waiver or yielding in this case. Judge Long found that the privilege was inapplicable because he said it's administrative, because you've picked out and picked on the library board when you staggered terms. You didn't stagger any other board terms. Not that we picked on the three plaintiffs, but we picked on the library board. But the only statute that can stagger library board terms is the library board statute, 25214. That has no application to the other boards and commissions that function in St. Tammany Parish. So to that extent, we believe that it is an institutional question that the appellees are raising down in the proceedings below, and I welcome the opportunity to brief that issue as Your Honor has set out. Thank you.
Thank you very much. We have both of your arguments, and this case is submitted.
Thank you.